Hello, welcome back, or good day. Sunday, the 17th of April. Just going to let everybody know we're having a live show, and today's presentation, entitled The Rule Against Perpetuities, Equity and Trusts, Part 1 of 2, shall begin. Thank you. I will be but a moment. That's not working. Bear with me. More fingers and thumbs on this sunshiny bank holiday weekend. Give me a moment. Thank you for your patience. I hope you enjoy today's show. We are about ready to do business. Yep. I think I've spelt perpetuities correct. I do hope so. Let's show me boat race. Ciao, good day. Bosh, much love to you. I seem to be sat on a bit of a wonky footing. So today in this show we're going to be looking at, as the title says, the rule against perpetuities, and this will be part of a two-part video series on this particular topic. Let us begin. It is 6 pages long. It's forming part of my equity and trust presentation. I've done the certainty of intention 3-part video. This now needs to be presented to you, and then we'll move on to the other 2 remaining areas of the certainties of trust: intention, objects and subject matter. There'll be 9 videos on the 3 certainties in total, short ones as you've asked for, and then 2 short videos on the rule against perpetuities. Thank you for joining. Happy bank holiday. We'll be back later tonight, myself and Kevin and available admins, and we've got a live show, Easter bank holiday special. It's going to be entitled Highway to Heaven, about 8:30, 9 p.m. GMT, so I hope you can join us for that, and we shall get on to the Easter topic. So without further ado, let me get the live chat up. It is in the public interest that property, both real and personal, should be able to be alienated freely. There is a rule that property may not remain in trust perpetually or for too long a period, and this is known as the rule against perpetuities, or perhaps more accurately, the rule against remoteness of vesting. One of the most common causes over the years of invalidity of interests under a trust has been failure to comply with the rule against perpetuities. Since medieval times, English law has been subjected to the tensions between 2 conflicting influences: owners of land and other types of property have generally wished to tie up their property indefinitely, usually for the benefit of their family or for some institutional cause. While the courts and the legislative rules have always felt that it is in the interests of the nation as a whole that property should not be made inalienable and that money should be allowed to circulate freely and be spent. So the result of this has been somewhat of a compromise. This is a rule that derived from public policy. In other words, it is a public policy and a good economic sense that property, both real and personal, be alienated, that is sold or given to someone else freely. Keyword freely. Property should not remain in trust perpetually or for too long a period, otherwise all property would end up in a trust, and this is the purpose of the rule against perpetuities, or one of the purposes, should I say. And then there is case law references here of Stanley versus Lee of 1732 years, 1732. There is an early reference to the rule against perpetuities, and it came from this particular case. It is early compared to, it's nearly nigh on 300 years old. It was stated that a perpetuity, as it is a legal word or term of art, is the limiting on estate, either of inheritance or for years, in such a manner as would render it unalienable longer than for life, or lives in being, at the same time and some short reasonable time after. I have joined estates of inheritance and for years together, because the law does equally abhor what is called a perpetuity, in the one as in the other, the reason of which abhorrence is the mischief that would arise to the public from estates remaining forever or for a long time unalienable or untransferable from the hands to another being. It would be a damp to industry and a prejudice the trade, to which may be added the inconvenience and distress that would be brought on families whose estates are so fettered, was the quote that I've managed to find during my research. It is contrary to public economic policy that property should be held on trust, or in trust, the term is on trust, unable to be bought or sold for too long a period. You cannot render it unalienable longer for life or lives in being, and some short or reasonable time thereafter. That is the old rule against perpetuities. In other words, a trust can last for the duration of one person's life, plus a short or reasonable time after, which has been historically 21 years. So I get a lot of questions about trusts and how long they can last for, and what happens when the testator or the settlor or whatever position and type of trust that is being expressed dies, and then the property vesting into the beneficiaries, and certain technical questions regarding the lifespan of a trust, what the rules are, the particulars of this, and how to make sure that the property remains within the family estate, and how to do this concisely and correctly and in accordance with the notions of English law and the courts of equity, the courts of England and the high courts of equity. And we also have mentioned previously about the age of majority. Again, we talk about military terminology, Latin terminology, French terminology. The language of English is quite diluted with the foreign tongues, amongst other languages that we've brought to you, styles and grammatical context and syntaxing and syntax, grammar, correct sentence, and it's a minefield. And this video hopefully will serve as a good segue to go through and to highlight why SPLs, Royal We, have the opinions that we do, and how we back them up with concise, clear, referenceable substance. It's not supposition, it's not our belief, it's as real as it is, to quote my man Josh. That's all I'm going to say. I like that saying. It's as real as it is. So a trust under the old rule of perpetuities could only last for the length of one person's life plus 21 years. And 21 years being the time of which the children, the assets, the offspring need to reach their majority. And until the late 1960s, majority was 21 and not 18 as it is today. So you may know of 21 years across the pond and 18 years here in England as the legal age, the age that you reach where you are no longer considered a child. You are no longer civilly inactive. You become civilly active. You become legally responsible. And we've also termified it at the age of 21, getting the key on the birthday card, which is tradition, custom and practice. 21 years. You may have recently had or know of someone who's turned 21, and predominantly the born day card will have a key on the cover. We talk about the age of majority. Again, church and state being mixed, languages being mixed, generals, the general public, the secretaries, the chief of staff, chief in staff, these terminologies and offices, public offices, offices of the directorate, executive, the UK government, and for some instances all across the realm in various continents and nation states, the language and the offices and the terms are the same. The Surgeon General, okay, so infantry, the first line of defence within the forces, the army, and etc. So major is contained within the age of majority. The major has a certain rank and title within the forces. Okay, so we appreciate that to some it's a little bit, discombobulated, but for us, this is what we've come to see and realise, and as we connect the dots and go forward into finding out the truth, what the truth of the facts of the matter are, from the Vatican to the kings to the presidents to the prime ministers to the government, all the way down to the lower ranks of I say lower ranks, but the working class, middle class, etc. Language of the law society, implied meanings, terms and definitions. It's important that we get the terminology out there and you become familiar with these and its implied meanings and the particular jurisdiction and constitutions that they apply to. And 21 years being the time of which the children need to reach their majority, and as I said, until the late 1960s, majority was 21 and not 18 as it is today. Feel free to go and fact check and check out everything that I'm presenting to you. And once again, there is no legal advice ever given and is not being given here. It's just my private research, discoveries being brought to you. If you require legal advice, you would need to go and see a legal practitioner. Majority, at which point they would become entitled to hold the property absolutely. And let's put it another way, because as I've said, I know some people struggle with this concept of perpetuities and the rule that it is encapsulating when considering expressing trusts and the particulars of the requirements of the trust and for a trust to be valid, and how to ensure property is looked after and correctly, titles and rights are correctly bestowed upon the correct parties for the correct amount of time. So in other words, if a person dies after they have a newborn child, the 21 years gives the child long enough to reach the majority, plus a possible 9 months, because if, let's say, the life tenant is a man and the property is held on trust for him during his lifetime, and then his children upon the youngest of them reaching 21. It is therefore possible his wife is pregnant at the time of death, in which case it will take 21 years plus 9 months for the blood asset offspring child to reach majority, or the age of majority. Although there are no cases on the extra 9 months, it is commonly accepted that this would be the case. That is the traditional rule of perpetuity. All private trusts must have within them a provision for their ending within a certain period. Important to note there. If there is no such provision, then the trust may be void. In that case, the trust property would return to the settlor, and that would be on what is known as a resulting trust. So all private trusts must have a provision for their ending within a certain period. If you have a private trust, you've expressed a private trust, or it's important for you to check, that there is a provision there for their ending within a certain period, or alternative provisions of succession, we will say. This is usually done by vesting any property left over absolutely into children, our blood, or grandchildren, etc. of the settlor. There is no such provision, or if there is no such provision, the trust may be void. And traditionally it was automatically void, but the law seemingly has slightly changed. If a trust is void for perpetuity, the property will return to the settlor on a resulting trust. In other words, it will go back to the original owner. And before April 2010, the trust property had to vest. In other words, the legal and beneficial title had to be held by the same person or persons within a life in being, plus 21 years, or within 80 years. A life in being was usually the life of the first beneficiary. If you've never heard the terminology life in being, which many of you will not have, then that explains a little bit there, and we'll come back to that in video 2. But it could be someone else's life, such as a member of the royal family, which was actually seen in the case of Re Hawley Town. Perpetuity period in this particular case was 21 years after the death of the youngest descendant of George VI, and that was he was living in 1948. Before April 10, the trust property had to vest within a life in being plus 21 years. You could set a fixed perpetuity period in that 80 years that the property vested in the beneficiary goes to charity or whatever you choose. This rule allowed the settlor to leave property to his or her children and then to his or her grandchildren, with the property vesting in the grandchildren when they reach the age of 21. Any attempt to control the disposition of property beyond that point, i.e. beyond the perpetuity period, was held to be void, and that would then invalidate the trust. The life in being test allowed a life interest to be held by a person and the remainder passing to their children on reaching 21. There was a possible gestation period allowed so that property could pass to a child on ventre sa mère at the time of the life tenant's death. So that is the possible 9 months extra in layman's terms. So let us take a look at the wait and see rule. Now, under the old rule, and that is under the common law before 1964, the mere possibility that property might not have vested before the end of the permitted period was enough to invalidate the trust ab initio, that is from the beginning. This is the basis of the judgment in Air Jamaica versus Charlton 1999. This is very interesting, and I hope you enjoy this little section. A Privy Council case from Jamaica in which the old rule against perpetuities was applied. Although this is a relatively recent case, Jamaica still relied on the old common law of equity, Rastafari, I and I. That is the law before 1964. They had no statutory provisions on perpetuity, and the law in Jamaica was the same as the law in England and Wales before 1964. In other words, the law in Jamaica applied the common law, in that there was just a possibility the trust would continue for longer than the life and being plus 21 years, then it would be automatically void. This was a case of a pension fund which provided a pension for Air Jamaica employees upon retirement and for their widow and designated beneficiaries after death. So employees, when they joined the company during the pension scheme, and money was automatically taken out of their packages and put into the pension pot. The employer, Air Jamaica, made contributions to the pension pot, and when the employee retired, the accumulated pension pot was used to provide the benefit for the employee on their retirement until the end of their life, and the benefits of the pensions would have gone to the widow until the end of the widow's life too. It was held that each employee's pension fund was a separate trust, established at the time that the employee joined the scheme. The power to provide benefits to widows offended the rule against perpetuities, as it was possible for a person to marry after the constitution of the trust, a person who had not been alive at the date of the constitution. So it was held that each employee's pension fund was a separate trust, and in other words, if you had 5,000 employees, there would then be 5,000 separate trusts. Each of these trusts had to comply with the rule against perpetuities. The trouble was that the power to provide benefits for a lifetime to the employer, as well the widow until her death, offended against the rule of perpetuities, because it was possible for a person to marry after the trust had been formed, a person who was not a life in being at the dates that the trust was constituted. So to explain this in a bit more depth, if the employer and the employee and his wife are both alive when the trust is created, they are lives in being, and therefore the trust would be valid because the trust would only last the remainder of their lives. However, if the employee is 18 when they signed the trust, he will become the life in being. If his future wife is not born yet, then the employer will become the life in being. The wife who he marries later will therefore not be a life in being, as the trust in this case is meant to be valid until the death of the widow who is a beneficiary. It would only be possible for the trust to be valid if the widow died within 20 years of her husband's death. And remember, the rule against perpetuities would mean the trust would have to end within a life in being plus 21 years. As the employer is the life in being for the trust to maintain its validity, the wife would, as I just mentioned, have to die within those years, as the trust said the property is vested in her for the remainder of her life, because otherwise she has outlived her perpetuity by the mere fact that she stays alive. So to explain that again and give you an example, a person who joined the scheme at the age of 18 might at the age of 50 marry a 30-year-old. If the employee died at the age of 60, the widow or widower, age 40 at the time of death, would easily survive for more than 21 years after the death of the beneficiary, thus making the duration of the trust more than a life in being plus 21 years. The life in being the employee, and the 21 years is the maximum time for any children alive at the death of the life of the beneficiary to reach majority and be entitled to absolute ownership. It was possible to join the pension scheme when they were age 18 and to start working for Air Jamaica, so it would be possible to marry someone who was not alive at the date that the trust was formed, and that person would then be entitled to widow's pension, and she may live for more than 21 years after the death of the employee. So in those circumstances, the trust would subsist for longer than their life in being plus 21 years. I hope I've explained that correctly, and forgive me for getting employer mixed up. It's my dyslexia, and I have to take extra time to be careful with this explanation. The trust was said to be for the benefit of the employee, then his wife when he died. If both were alive at the time that the trust was created, this would not fall out of the perpetuity period, because they would both be lives in being. However, if the wife was not alive when the trust was created, the employer would be the life in being. This would mean that when he died, the trust would have to come to an end within 21 years of his death. Employee. However, because the trust allowed for the pension fund to invest in the widow and took her death, it is very possible that the trust could run for longer than 21 years after the employee's death, thus falling foul of the rule against perpetuities, 21 years plus her life in being. Because that was a possibility, that was enough to invalidate every single trust in the pension scheme, and as a result, Lord Millet said that every single pension fund under the scheme was invalid because under the old rule pre-1964, the mere possibility or sufficient to invalidate a trust, and before the change in the law, the following case happened. So we go to Pilkington and Inland Revenue Commissioners. In this case, the trustees exercised the power of advancement, which allowed the future beneficiaries to receive up to half of their expectant share of the trust capital to create a new trust for the 5-year-old daughter of the life beneficial. Now this, you may recognise Pilkington, the name Pilkington, the Pilkington family who made a lot of money out of glass, and in this, the manufacturing and distribution of glass. And in this case, the father was a beneficiary under a trust. He was a life tenant of the trust, and his daughter had remained in the trust. In other words, she would come into the property when her father died and she had reached 21. Now what the father wanted to do was set up a new trust for his daughter, and the trustees had what is called a power of advancement, and this allows trustees to give property to someone who will become entitled in the future, and this is an express power in the trustee. So as long as the life beneficiary is okay with it, the trustees can give up to half of the trust money to a future beneficiary. So in other words, as the trust said, the daughter would be entitled to the trust capital when her father died, but the power of advancement meant she could get up to half of the trust capital before her father died, and he was okay with that, and said that money could be taken out of the trust fund to settle a new trust for the benefit of his daughter, who was 5 at the time. So the plan was to take money out of the trust capital and use it for the 5-year-old to set up a new trust for the benefit during her lifetime and for the benefit of her children too. Now, as a new trust was born out of the old trust, the perpetuity period was taken as from the establishment of the original or the old trust, as the daughter wasn't a life in being at the time of the old trust was created. So then the new trust was void. Okay, so the resettlement is fine, but there was a problem. The daughter was not born when the first trust was set up, and if you take money out of an existing trust and use it to set up a new trust, the perpetuity period must come from the original or the old trust. So in other words, as property was taken out of one trust to set up a new trust, the House of Lords held that the perpetuity period should date from the formation of the original trust and not the new trust. You cannot create a new trust out of the old trust to get around the perpetuity rules. As the daughter was only 5 years old and not born when the father's trust fund was set up, she was not a life in being, so the trust failed and was void for perpetuity. So the money went back to the original trust. The reason was, or that there was a possibility, or rather a probability, that the daughter would outlive her father by more than 21 years, in which case the perpetuity period would be exceeded, and this was sufficient in 1964 to invalidate the trust. So this was another case in which the old pre-statute common law was applied. There was a specific response to this case, and in 1964 Parliament passed the Perpetuities and Accumulations Item 1964, and it was in this case that the wait and see rule was introduced. So that's the first part of a 2-part video, and I hope you can understand why I've decided to do this in 2 parts, because I think you'll need to watch and research and let that digest, and go and check out the Air Jamaica, I think Stanley versus Lee, 1732, as I mentioned there, and then you would need to actually look at the Air Jamaica case as well, and the dates and times and years of what I've given you there. Air Jamaica versus Charlton 1999 with the Privy Council case, okay, and check out the rule against perpetuities externally. Check out the terminology life in being, okay. I think it's quite pertinent for you all to know about the age of majority and what that means, and those of you that are knowledgeable or aware of trusts or have had friends that have come into beneficial, you know, statuses of being a beneficiary of a trust. I hope that explains and sheds some light on why it is 21, and you know, how to vest property in trusts and to ensure titles and rights are expressed have been presented to you via my previous videos. And for those that may not be aware, I'll screen share and show you. I'll add this video to the playlist, so you've got them all in one place to make it convenient and easy for you. But if you just give me a minute, I will screen share, and we will show you where the rest is until I put them all into a playlist, because as you can appreciate, they're being designed and cast now, and I can only add them one at a time as and when I produce the content. Okay, so let's just do that. You can type in here SPLS Pro, we go to this channel, hopefully playlists, the three certainties, equity and trusts. You would click there, and then we have playlists, certainty of intention part 1, equity and trust part 1 of a 3-part series. Okay, so you need to watch that if you haven't already, part 2 of 3 and part 3 of 3. I'm needing to build up this channel more so than Indiglo, my backup channel. So SPLS Pro, SPLS space Pro, and I believe if I look at Indiglo, I've mirrored them just in case something happens later, and we've got the three certainties and equity and trust presentation that I'm doing now here as well. But I would prefer you to go to SPL's because this channel's rather busy and cluttered. I'm trying to ensure that all the equity and trust presentations and topics are within SPLS Pro, and so it's a you know, clean and clutter-free channel. I have done some recent videos that may be of interest regarding persons, legal personality and strawman, etc. There's some public chats that have gone on recently, and presentations and other non-exclusive presentations and chats I've done on my own, as well as with Kevin and guests and admins. I've done a video there, introduction into equity and trust law, showing you some of the publications and the areas of which these references come from. Okay, so I would appreciate you doing, you know, familiarising yourself with the content that has come up recently, been presented to you recently. Videos on SPLS Pro, that's interesting in itself. How evil runs the world, prison on earth, one world, new world order. That's related to, but more about the banking, money changes, etc. Given the time of the year, April, Easter, bank holiday weekend, I'd like you to go to SPLS Pro and bookmark that, and 2-hour presentation, 2 weeks old. Have a look at that, and any other relevant videos you think, you know, you may be interested in. As always, like, subscribe and share across the domains that you frequent with your friends and family and groups and etc. Introduce myself and the SPLS fam to those that you care and love. Okay, I'd like to go to the chat and see who's in and say what go on. And remember, tonight we have a show, a stream from 8:30, 9 p.m. GMT with myself, Kevin, any available admins, and we're going to talk about Easter, rebirth, highway to heaven, spiritualism, synchronicity, souls. I'm going to present something that I think is quite new to you, even though it's a couple of thousand years old, regarding Angel Gabriel, crucifixion and rebirth. That's going to be a pleasure and a delight. So if you're interested in any of that, then remember to check or look out for the video link that I'll share later with regards to us chatting tonight. Hello to Barnster, Paul, what, Jerry. The elites and their factums must use instruments to pass on their ill-gotten gains to their property. Wonder how? Yes, Paul, but also we are able to utilise equity and trust in various forms and look at the protection that is available for us, and transfer of titles and rights, and how we do that, how it is done. Easy for those that create a maze to have their hidden roots out. Yes, Jerry. Astro Thief. What go on? Ciao ciao. Let me just check the chat on Indie as well, because I'll need to add you as moderators. Astro Thief. Bosh. You're now in blue. You got your spanners. If you have any questions, type them in now and I'll do my best to answer them. Got to go, but great to hear this aspect. I'm a newbie, so steep learning curve. Happy Easter, everyone. Albert, what go on? Much love to you, bro. How do? That's the public Telegram link there for those that are interested. Posted by brother Albert. We go to the home page. Let me check the chat. So yes, I hope that sheds a little bit more light on the areas of equity and trust, and I would like you to frequent yourself with that playlist on the 3 certainties. There is going to be the certainty of objects, the certainty of subject matter to follow on. There is going to be another second part to this short video with regards to the rule against perpetuities, and together over time we will learn how to correctly administer our estates, saying goodbye to Magna Carta, practical lawful dissent, constitutional arguments, and we will border into the triangle window and various positions within that. We'll look at how to analyse the existing trusts stemming back from Pope Boniface in 1302 and the first testamentary trust that was expressed, and the subsequent proclamations that was done by the Vatican City. We will look at the merging areas of church, state, monarchy, banking, courts, equity, trust, language, instruments, deeds, title rights, split titles, property, and into biblical, Mosaic, Abrahamic. It's quite an extensive area that's encapsulated the realms of ecclesiastical, commercial, legal, lawful. They're all related by extension of one another. There is an originating source, Old Testament, New Testament, Romans, Greeks, British Constitution, the Commonwealth, all under the crown of the papacy, so to speak, and moving forward through the annals of time up to present day today. So I try to give you the source, reference, case and point, precedent, landmark cases that let you know, and the substance over the form, so you know the information is as accurate and concise and as real as it can be, as relevant as it can be. I'm taking note of the most frequently asked questions with regards to expressions of trusts, formulation of trusts, types of trusts, and helping you to help yourselves. So if you are able to visit our homepage or support us in any way, if I wouldn't see why you wouldn't be interested in coming to join our private community. And there's the homepage there. You would scroll down and consider becoming a supporter. You are able to donate privately via a bank transfer to our trust account and obtain an account without using the automated systems there. You are also able to donate separately by using the button at the top of the page, should you wish to help our private community, give us resources, help us grow. I would like you to consider becoming a supporter of our foundation educational private trust, if that's something that you think would be beneficial to you and you could benefit by. Then I'm happy to have you. We're happy to have you in our family. Okay, and when you join, you do get a last will and testament complimentary editable Word document download here. We have got bespoke forums for you to look at with regards to the repository that we have with the information that is critical criteria for you to get versed with, familiar with terminology. We are building an area of educational nature regarding trusts, equity, common law versus equity forum, equity case law, high courts of justice, chancery, etc., trust law in itself. We've got workshops and video forums, private property, trust, assets, title transfer, the rules of and law, Abrahamic, universal, Hermetic law. There's a lot of spiritual goings on and insight in here as well. It's not just strictly legal and lawful. There's a lot of segues to insert relevant particular information of which is quite pertinent to what is going on. We've got an update and announcement forum, a tax forum, council tax, public law, illegal offences, common law, crimes, notice of intent, understanding and claim of life right. It's a 4-year-old forum that's continuously under improvement with regards to obtaining our equitable relief, expressing equitable interest, claiming back the security instruments of such, and moving into the private transferring, endorsing, transfer via endorsement, managing the estate, holding the UK Treasury as the intermediary for the discharge of charges, management of estate, title rights to security interests that may be, running, that are seemingly running with regards to the commercial intercourse that we see. So yes, we've got evidence of life, essence, incarnation to think about, ecclesiastical deed poll, managing your person, your corporation, doing business as the all caps, looking at how to obtain equitable relief and remedy, not trying to find legal loopholes and circumventing equity and trust, but how to utilise the existing infrastructures, institutions, and what's at play presently, moving from legal to lawful, from public to private, and doing it correctly rather than trying to find technical workarounds where we circumvent equity and trust and find other such ways of managing to not have legal liability in the public. There's a lot of ideas and premises going round at the moment, but I'm not sure they're entirely wholesome. They may work for a certain amount of public liability and discharge, but I don't think they will ultimately get settlement and full satisfaction guaranteed, is all I'm going to say there. So there are some rather clever, intricate workarounds, legal workarounds, but I'm not sure that they are the desired pathway, as we have a bit more insight, knowledge We've done our due diligence, and you see the work and the effort that I and the admins and our associated union private trusts that we have with one another have uncovered so far. But that was something, that terminology, notice of intent, understanding and claim of life and right, is something that there's a lot of posts and threads in there, and it's under continuous improvement, but the premise is correct. We have a government, Westminster legislation, secular codes and person, main forum, and the subcategories in there are courts, civil procedure rules, protocols, language, status and capacity, the Crown, the Crowns themselves, UK constables and police. We have the bespoke SPLS Pro last will and testament, asset protection for private property, continuously moving on, and also power of attorney is encompassed in there, the Office of Public Guardian. So that's something that's quite imperative and needs to be looked at by all, or at least considered. A particular area of interest of mine is etymology and phonics, the sonics of the phonics, the Phoenicians, the definitions, the phonetic Hebraic texts, Sanskrit, all kinds of languages in relation to the origin of the words, the etymological root references, and obviously the phonics of the Phoenicians with the definitions. We have an international law forum, so we have an American law forum there, which is quite busy, and I'm happy to oblige the best that I can. We are happy to oblige. We've got civil, felony, penal code, offence, infraction versus crime, international news and updates forum, an international universal declaration of human rights and fundamental unalienable rights. And then we've got true law and law doctrines that I'm building up. That's a new addition to that international law forum. We've got banking and money. Cryptocurrency is one subject topic in there, and then money, debt, credits, intrinsic value, endorsement, accepted for value, bills of exchange, all of those related topics to do with promises, cash, credits, the fiat system that we've come to know of, including the revelations by Professor Richard Werner, and articulation, presentations, videos, documents supporting evidence to do with finance, fiat, banking and money. Kevin's DWP and Employment Support Allowance Work Capability Assessment Forum. That's very busy and is continuously being updated, and lots of references in there. A shout to Andy from Wakefield for some recent information that's come through there. You've got a Chief Civil Enforcement Officer, CEO, not a Chief Executive Officer, Civil Enforcement Officer, debt collection agents, aka bailiffs and sheriffs forum there. It's quite heavy and is continuously being built upon. We've got a healthy forum, things that to do with your spiritual side, your energetic side, your well-being side, mental health and physical health is all in there. Buckinghamshire fullerene and carbon C60 is one of the interesting topics that was recently added in that. Community spirits, corona, COVID type related post, church law, Vatican popes, antiquities and antiquitech, Roman, pagan, Catholic, Catalytic, pre-Christian gnosis and more. The penalty charge, notifications, infractions of the Road Traffic Act forum. We've got our own homegrown, in comparison to Franco Collins' homegrown grassroots ecclesiastical deed poll, evidence of life, essence, guidance forum that we've created there. I have my own forum for unrelated but connected topics, an escape room for things non-equity, trust, lawful and legal, just a random room to have some fun in. A new initiates forum to pop in and say hello, a general discussion forum which is proving quite popular, a data protection act 1998 data, GDPR forum and related topics, a local forum where you can look at getting help by county, city, town, etc. for you to liaise and connect and network and form private trusts and unions there. Anders' Swedish Suveran forum. forum for our documents, issues with documents, passwords, to get feedback from presentations and publications that we've done there. A sovereign park forum with regards to obtaining private land title rights, holding land property, common hold, freehold, leasehold, discussions, topics there, which is being built up. A new support, questions and interaction Q&A forum, a welcome forum to say hello and introductions. Our Sovereign Masters Guild Education Workshop, General Workshop Feedback Forum, a Magna Carta Forum for discussion, not endorsement of the Carta, charters, parts, articles, etc. Help you, forum for tutorials for videos for site navigation and further help into utilising the site for full benefit. You got a complimentary castle safety welcome pack, free download, how to keep your property secure, notice of implied rights of access, removal of common law property trespass, things like that. A GANS forum, just a gas in a nano-solid state that we was exploring, a science forum really. Social services, offspring, assets, children, less abled, adult social care, children's social care, some works and particular posts of Santos Bonacci that he's done in the past, iconic videos that he's done. Anglo Creditors Certificate Forum, evaluate information given from other YouTube channels, creators, thought leaders, Ronley Stewart, Justinian Deception, and talking about credit, certificate, birth certificate, certificate of live birth, all that kind of jazz. So there's a lot there going off simultaneously. Okay, we've got a courses page that's accessible to all for free, as part of the domain. Nothing is hidden, no VIP areas as such, but there are private areas with regards to access to our equity and trusts, Jedi orientation pages there. So that's a little bit of who we are and what we do, what we encapsulate there with regards to this subject matter. So we primarily focused on equity and trust, title rights, looking at property. We're aware that other trusts are in existence and have been formed since the first testamentary trust of 1302 and Pope Boniface, the creation of the Crown, Eterni Regis, convocation, the claiming of property, souls, rights, etc., and moving forward through time, through the annals of history, until present day, looking and analysing at the courts, the instruments, the acts, the statutes, the legislation, the common law of England and Wales, courts of equity, the pre-action protocols, the civil procedure rules, the civil court practices, how to communicate with higher levels of government. And we primarily focus on England, Anglo areas, but we also are aware and able to look at America, Australia, Canada, Europe, and other such entities, establishments, Commonwealth, foreign territories, nation states, and applicable laws, legislation, statute, courts of equity being recognised by a lot of the courts around the realm, England being a part of the lawful procedures in places such as India and continents, Jamaica I've mentioned in this video there, and common law and equity and privy councils, how this is extended from England, English civil practices, English law systems being by extension through foreign territories, Commonwealth extensions, and Hong Kong judges in wherever, foreign territories, countries, presiding with Halsbury's law, equity and trust, civil court practices, civil procedure rules. It's not identical, but we've stopped learning from Bill Turner, New Zealand, Canada, Australia, and other thought leaders and YouTube channels and domains out there. What we've started to do is focus on what is here, what has happened here, and how by extension it has then affected, such as America, how America was taken from the Aborigines, the native Indians, and colonized, and then moving, all of that historical encapsulation, and how England has played a part in foreign territories and occupied territories and law, equity and trust. Then we look at the City of London, the corporate City of London, under the Vatican, the Masonic Sun Temple, the Templars, the Templar law, the legal law society, the biblical connotations and references, the axioms, maxims and biblical precepts that the 10 commercial maxims of law have within the London Legal Law Society, Templar law, and how that has extended into banking, into courts, business deals, being done via securitized instruments, instrumentation, in interests in certificates, or financial future interest, financial future securities in themselves, banking, Seta KV, Seta K, courts, ecclesiastical, and security instruments being used within those realms. So, I think I've given you a good enough idea of the perplexity and the multifaceted layers of the dimensions that are running simultaneously within our coexistence as public trust, co-trustee, co-beneficiary of the public trust, and how we look at those and analyse those, how we move from public to private and utilise and express private trusts, and do that in such a way that is going to be enforceable and recognisable under English law or laws pertaining to your state, nation, landmass, territory. And here we have, I clicked courses section. We have some courses that are accessible to all freely. A conditional acceptance workshop, it's under work in progress, but there's a lot in there. How to stay in honour, and how to, when you get presented with something, claims as such, you can deny them, accept them, or conditionally accept them. How to keep clean hands, how to remain in honour. We've got questions for a judge, a banker, Latin bench, a robe, an arbiter, signing without assuming public liability, and affording autographs, all unalienable rights retained. We had a NHS England GDPR non-consent data sharing selling notice of instruction, even though it's to do with NHS England. GDPR, European data regulations themselves, are pretty much universal internationally, interchangeable, and remain roughly about the same premise for data and management. So that's part of NHS England non-consent, but it's relevant information for all. That's how you get access to our Trust and Equity Jedi orientation access pages and further information on that. You need to be a supporter of our private domain foundation educational trust, and then you can get access to this via further donations, and we're about to start that again, a second run of our homegrown grassroots equity and trust Jedi orientation lessons workshop guide. We got stop and search officer trustee interaction scenario, again focused on England, but we are aware that there are state troopers and officers around the realm, and we try to unilaterally express that terminology which is useful for all regarding constables, officers, troopers, etc. So we got a lot going on. I hope that's of interest to you. Just a little bit of a preview for you there. I want to say hello to Julie. Welcome. Thank you. June, not Julie. Put my assets into a private statutory trust. Do I need to do anything more to save my assets from the public? You would need to have a look at the playlist. Let me get you the link, and then yes, you would need to review some of the videos on this channel or SPLS Pro and look at the playlist of the certainty of intention. Start at the beginning, familiarise yourself with the language, the terminology. I'm not sure by what you've put there. We talk about primarily private trusts, express private trusts. You've mentioned private oblique statutory trust. Okay, we need to talk about that in some respects. Do you need to do anything more to save your assets from the public? You're not saving your assets from the public, you're moving property from public into property held on trust as a res in a trust, and you're splitting title rights from you having equitable title to passing legal title to the trustee and equitable title to the beneficiary, doing correct estate administration in the form of private trust, express trust, testamentary trust, discretionary trust, various forms there. Yes, if you look at my playlists here on SPLS Pro, 3 certainties, equity and trust. I will view full playlist and put you the link there. They are on this channel as well, but I'd like you to build up my backup channel, SPLS Pro YouTube. So have a look at those. Check out our publications, find us on Facebook, look at our website, our domain. Come to our Telegram groups, keep abreast with this channel and its output, and we will work together as one with regards to that. So start at the beginning as always, take your time, and I think that'll do for now. I'm going to enjoy the rest of the bank holiday Sunday. We'll be back later. We'll aim for 9, maybe 9:30 at the latest, and we're going to talk about Highway to Heaven, spiritualism, and all things related to Easter, the Christ, Golgotha, and I look forward to that with Kevin and any available admins. So we splintered off from the rule against perpetuities, but I think it was relevant and productive. I want to say thank you all, much love. Thank you for your support and time. Bosh, I will put it there. Fist bumps. And ciao for now. Share, like, subscribe, support, look after one another, and we'll see you soon, Button Moon. Alright. Thank you, June. Much appreciated, much love. See you later, scribes. Ciao bello.